Yes, Dr. McCoy.
Yes. My lady, my lords, kia orana. I appear with my learned friends, Mr. Tim Parker and Ms. Zoe McCoy for the appellants, our learned friends, Mr. Isaac Hakaka, to your far left, my lady, and Mr. Tony Manarangi appear for the respondent. My lady, it's hoped, indeed expected, that you have before you the appellant's case, the respondent's case, and the appellant's supplementary case. There ought to also be in South Pacific Blue 3 volumes of the record. The first item in Volume 1 is the judgment of the Court of Appeal. The first item in Volume 2, tab 14, is the judgment of the High Court. Your ladyship should also have in purple a bundle of exclusive Cook Islands materials and authorities, and finally in pink a smaller bundle of materials from other jurisdictions. I should inform your ladyship that the appellant has served the Solicitor General of the Cook Islands with all the papers, lest he wish to potentially intervene in these proceedings, but it appears that he has remained inert.
Or neutral.
Or neutral. A maximum 3 hours have been allocated for the appellant's argument. With your leave, that'll be shared between myself and my learned friend, Mr. Parker, who will follow on ground 3. If I could now articulate for you the grounds of appeal.
Supplementary submissions. I do not have the supplementary submissions.
They have not come
that is
separately.
Probably my fault.
They're in this document called the Index to Electronic Bundles.
Okay. Yes. Right. In that case, I do have it.
At page 586.
Okay. I do have it, yes.
Thank you, my lord. My lady, there are effectively 3 grounds of appeal to which this case can be distilled. The first one, if I use shorthand, is the procedural unfairness ground, namely that the applicant, the present respondent, did not serve the proceedings on all of the registered tenants in common, half of whom live out of the jurisdiction on a permanent basis.
But was that ever raised before either the trial judge or the Court of Appeal?
In the Court of Appeal, the matter was raised, and I can show you that in the transcript.
Yeah, but it wasn't raised before the trial judge?
It certainly was not. That involves a consideration of the High Court rules, the inherent jurisdiction, and 2 constitutional rights: the right not to be deprived of property except in accordance with law, and the right to fundamental justice, which is an express right in the Cook Islands Constitution.
Who's taking the point?
The appellants take the point.
And they were served?
They were served.
So what are we to make of a point which is in the interests of other people who presumably know of the proceedings and haven't intervened?
My lord, the question is, that assumes the very point. Unless there is service on them, they won't know of the proceedings. I would submit that the reciprocal and mutual failings of the appellants and the respondents do not merely self-counsel. There is still the fundamental issue that those who are the co-owners of law simply were not aware of the existence of the proceedings and also were never served with the evidence.
Your complaint about the procedure not being in accordance with law, as I understand it, is not really that any rule has been disobeyed. You criticise the rules of court, which don't require this.
That is certainly part of it, my lord. I submit there's a radical deficiency in the rules of court, yes, because it simply doesn't contemplate the situation.
No, but there has been compliance with the rules of court. Your criticism is the rules of court should have provided for service on all the tenants in court.
Correct.
The procedural point is not dealt with by the Court of Appeal.
No, it was not. It's referred to in argument, and I can show your lordships the passage.
Well, the one problem may be that if it wasn't taken at first instance and wasn't dealt with by the Court of Appeal, We don't have the assistance on a point on which there may be local sensitivities of either of the courts below.
I fully apprehend the significance of that observation, my lord, but if it is fundamentally of such a character that the proceedings have never been properly constituted in respect of the majority of the co-owners, because they simply are unaware of it, then it's a matter that your lordships will take into account in deciding whether to remit the proceedings to the High Court. Indeed, that is the ultimate order that the appellants submit ought to be made in this case. For that reason, and indeed for other reasons, which I will presently come to.
The majority co-owners are presumably spread around the world, being part of a large diaspora of people who've been born in but then later left the islands. My question is, tell me if the observation is wrong, but my question is, are their whereabouts all known? Are their whereabouts all known?
My lord, first of all, your observation is correct. It would be assumed that most of the Cook Islanders, through the immigration process, live in New Zealand or Australia. But of course, they can be spread Los Angeles, London, Hong Kong, can be anywhere. In terms of your second point, could your lordship please repeat it again?
My question is their whereabouts known? You contend you say the only compliant rule to deal with service would be service on all. And I'm conscious that there are conveyancing techniques in some similar islands, the one I have in mind is in the Caribbean, which deal with the problem in a very different way, in which those who have left are taken to accord with the decisions and conveyances of those who are still there.
My lord, the issue as to whether their whereabouts is known would be a matter of fact.
Yes.
However, as your lordship rightly observes, different jurisdictions have treated this issue so that a practical result can be achieved. So, for example, in New Zealand, in relation to the Maori Land Court, where there can be hundreds of co-owners under tenancy in common of parcels of land, New Zealand Parliament enacted the Te Turi Whenua Act of 1993, which is the legislation pertaining to Maori land affairs as a generality. And Part 10 of that has a specific part which provides that a manager of the lands is appointed because the whereabouts may be unknown, people may have deceased, it may be impractical to locate them. So there is conveniently a legislative fix available for the Cook Islands if they wish to borrow the precedent from New Zealand. And that simply exemplifies the nature of the problem. Unlike New Zealand, when there is specific legislation to rectify this deeply practical issue which affects legal rights, the Cook Islands have done nothing and continue to operate under the very crude terms of the 1981 formulation of the High Court rules.
Dr. McCoy, it's highly questionable whether we ought to be entertaining this particular ground of appeal.
Yes.
The substantive grounds of appeal are a different matter.
Yes.
So I wonder if you could move to the substantive grounds of appeal, and then we shall think about whether we want to hear you on the procedural matter.
As your ladyship pleases.
Is that all right?
Not at all.
Can I draw your attention to the fact, no doubt aware of it, when you reflect on it, that the procedural ground does not seem to have been one of the grounds in the notice of appeal to the Court of Appeal.
Your lordship's entirely correct. I say touché. This only emerged after there was actually confirmation that there was no legislation in the Cook Islands to prove a negative, namely the absence of something like the New Zealand equivalent, took much effort, and there had to be a number of solicitors and legal practitioners in the jurisdiction asked to confirm that there was in fact the absence. So your lordship's right It's not in the grounds of appeal as originally formulated. It appears, of course, in some length in the appellant's case.
That explanation appears in footnote
That's right.
5 to your
Yes, exactly.
submissions.
Your Lordship may recall it. I certainly do, when I appeared in Aorangi, where, in fact, on another occasion, I had to make a very deep bow to withdraw from a proposition that I had advanced on specific instructions. So, my Lord, that's exactly correct. Once bitten, very thrice shy in this situation before your Lordships. My Lords, could I identify, as my Lady Hale asks, ground 2? Now, my Lady, this is essentially a collation of 7 errors of fact and law. That may sound intimidating in number. It's not, because many of them commingle and interweave. There are 1 or 2 freestanding points. May I articulate for you immediately the 7 components of this ground?
Well, could you perhaps sum it up in a sentence and then break it down into the components?
Yes. The Court of Appeal wrongly applied Eurocentric notions to radically redefine the custom pertaining to succession to land. And they did that by imposing a very narrow meaning on family. In Polynesian terms, family is intergenerational. Court of Appeal, with respect, wrongly redefined family for the purposes of succession to mean only the siblings and the adoptive parents. The next component is the Court of Appeal, with respect, again, wrongly declared that the sole point of time when succession is to be decided is at the date of the deceased's death, such that it renders conduct subsequent to that to be inadmissible. By its own reasoning, however, the Court of Appeal betrayed that very ruling, as it took into account as the prime consideration matters that had occurred since the death. And the third aspect, and these 3, which I can call the definition of family, the timing, and this point, the consensus point, are somewhat interdependent. The Court of Appeal wrongly declared, as a matter of customary law, that there was no requirement for consensus as to whether an adoptee not of the blood could succeed.
By consensus, do you mean unanimity?
Unanimity. Now, my lady, a freestanding point. Those 3 points are deeply structural to the argument. A freestanding point is the learned High Court judge made only one finding of fact, namely, there was no unanimity. And he ruled that that was determinative of the application. So he therefore made no findings as to credibility, reliability, admissibility, probative value. The learned judges in the Court of Appeal decided not to remit the proceedings to the judge to make findings of fact. And they themselves ruled, and this is their word, they must make findings of fact. And I show you in due course the transcript. It was clear that even counsel then for the respondent was of the view that remittal seemed the just and obvious way forward. My lady, there are three other points. One concerns the Court of Appeal's decision that the sworn evidence of the adoptive parents in the adoption order, that the respondent would not succeed to their customary lands because he had already succeeded to his own natural mother's land, was insignificant for customary law purposes.
You say it was sworn evidence of
Yes.
both adopted parents,
No.
not just the mother?
No.
It was a joint application, only the mother was present, but it's a joint application by her.
So
and
she was
him.
acting on behalf of both?
Correct.
But did she say in terms she was speaking for both her interest and her husband's interest in relation to succession?
When I show you that, my lord, I can do that very quickly.
Yep.
She says, the boy will not succeed to our lands.
Our lands. Thank you.
The two remaining points, my lady, are the Court of Appeal wrongly evaluated the evidence. It's a fact that the family had successively permitted the respondent to have an occupation right, which can be thought of as a license, a mere license, and then a lease, and finally a vesting order. But this all pertained to only a 1/3 acre piece from one parcel of 7 acres. The Court of Appeal judges determined, as they say, this is their expression, a value judgment, that this meant the family had accepted the respondent for the purposes of succession to all 19 freehold parcels. We say with respect that is unsustainable.
So one parcel was
One parcel
7 acres. How big were the other 18 parcels?
I've asked that question, my lord. I understand it's approximately 250 acres. Now, much of this land has no commercial value. Some of it is sheer cliff face. But as your ladyship remarked in earlier Cook Islands authorities, commercial significance is not the driving force in relation to ancestral land. And the last issue is that the Court of Appeal wrongly considered and applied earlier decisional law. Now that somewhat requires me to invite my lady into the enchanted forest of Cook Islands customary law, and that needs to be done on a very short basis because the appellants would submit there are one or two very clear authorities decided by the Court of Appeal in the 90s which have created a regime that is understood and determinative. But in more recent times, the learned judges have sought to even out the custom, reshape and reconfigure or recontour it. Now, my lady, it must be acknowledged that there may well be an initial instinctual recoil against the conception that an adopted child of the blood does not enjoy via equality.
Adopted child not of the blood.
Sorry,
Adopted child not
not of the blood.
Yes.
It does not enjoy via equality a right to succeed to customary land. But in the Cook Islands, we will submit the Constitution, the statute and customary law, and the Court of Appeal below have all held and always held that in such a situation there is no right to succeed. Succession, however, can occur under very limited and defined circumstances where all the co-owners of the customary land agree. What the learned judges of the Court of Appeal appear effectively to have done is import some notion of democracy, almost even the balance of probabilities, that if a majority or at least the close members concur, that will suffice. We submit that the contours of the custom are concentric with the legal position as tenants in common. They are all co-owners. No subset of the co-owners can give away or determine the land owned by all together. And the blood-land link is ancestral, and the descent construct is the very essence of the custom to be preserved in the Cook Islands.
Mr. McCoy, could you help me on this? My understanding is if there was a single owner of a plot of freehold land, he couldn't give away or convey away that land.
That is correct.
So how is it that where there are, let's say, 20, they can?
Oh, they cannot.
Well, then how does the custom for which I thought you were contending, namely that all of the co-owners can confer succession rights on a non-blood adoptee who would otherwise have no succession right, work?
How it works, my lord, is the present co-owners, the tenants in common, can, under the custom, permit a person not of the blood to join the clan, and he thereupon, or she, thereupon becomes an additional co-owner, and amongst each other there would be a redistribution and a slight minimisation of the pre-existing rights to accommodate the new entrant.
You say it's not a transfer of an interest in property?
It's not.
I think the premise of my Lord Briggs's question needs examination, perhaps. I think the premise was that a single owner couldn't give away. But if you postulated a situation where there was no other member of the family,
yes,
whatever, anywhere in the world,
yes,
and there wasn't, as there was in the Emma case, some Ariki who then stepped in and tried to say, well, all right, I originally, was originally in charge of whatever clan you were involved, but leave that aside. Then, presumably, in that situation, if there was no other family member, as family is understood, presumably the individual could adopt someone and say, I accept you fully as my heir, straight away.
Yeah.
So it'd be just like all co-owners agreeing, he would be the only owner. There wouldn't be any co about it at all.
That's right. In the extreme situation postulated, where there is an extinction of the line, which was the Emma situation, the adoptive mother to the judge during the adopted order said, I wish Emma to succeed to my lands. And she did. She thereupon had all the rights, and as your lordship said, she became the sole owner. Yeah. She was therefore permitted as a customary owner only to further devolve that right under customary law. Right. Customary law certainly circumscribed what she could do. My lords, my lady, the third point in the appeal, which I will ask my learned friend Mr. Parker to follow to address you on are the three modes of ascertainment of customary law. Through the common law, the rule in Angu and Ata, decided by this board in 1916 and repeatedly followed and indeed applied in New Zealand. Secondly, through expert decisions by the House of Arikis and the Kutunui, together the customary paramount and subsidiary chiefs recognised for their roles in the Constitution and the statutes, which I will come to. And the third and final issue is under Article 66, capital A, subparagraph 4 of the Constitution, introduced only in 1995. The Constitution is from 1965. This provided that a body known as the Oronga Mana is permitted to make conclusive determinations of customary fact, usage and law binding on courts. And we will submit that applying either common law, expert evidence, or the constitutional route, each leads to the decision that the Court of Appeal was in error and the learned judge, with his unrivalled experience of Maori customary law, was correct. My lady, moving forward with your suggestion, I turn now, please, to the issue which would be ground 2 and the first component of that. Now, this is that the Court of Appeal, in a sense, wrongly did not remit this matter back. And as I've indicated to the board, no findings, credibility, reliability, admissibility, etc. were made by the judge. The Court of Appeal, however, decided, and may I ask you to come to Volume 1, Bundle 1, Tab 1.
Can you give me a page number?
Certainly.
I'm happy to add 8 to bring my screen into accordance with your file.
My lord, thank you. I believe it's page 12.
And so it's your page,
You think it's electronic page 12?
or paper 12?
I hope so.
What's
my
the first
lady.
words on the page?
Or the paragraph number. might
What's the
help.
paragraph number in the judgment?
45.
Yeah,
No.
No, it must
That's,
be my page 20.
that's the printed page.
yeah. That's page 12 in print.
I apologise if there is serious
Yes.
discord. We will seriously try to rectify
We're 8
this.
pages out most of the time.
I see.
But I'm quite happy if you give me the paper pages, and I will simply add 8.
Thank you.
Well, that's very kind of you, but I would prefer to have the sums done by the people who presented the documents.
So long as you give the other one as well, because I don't have a computer screen.
So that's what your juniors are for, Dr. McCoy. They are to give you the page numbers.
We hope they can add 8.
I'll try and add 8 too, but nevertheless, it's your business to get it right.
Yes. Now,
So you're on paragraph
I said 45, my lady.
45. So that is on page 20.
Right.
Is indeed
Then if
adding
you-
8 to 12.
If I do the +8, if you would now come, we've identified a pivotal point. If you'd be good enough to come to your 21, and you'll see a cross-heading, had the appellant's adoption matured by the date of death in the present case. And one sees there, Justice Isaac considered that the adoption of the appellant had not matured sufficiently because of the opposition to these proceedings from at least the 2 respondents who were next of kin. He did not attempt to determine whether the appellant had been accepted by his adoptive family by the date of death. This court, therefore, must decide whether there was sufficient evidence in the High Court to determine that question. Now, we respectfully say it wasn't for the Court of Appeal at that juncture, upon reaching that conclusion that on its findings the judge had erred. It was the only appropriate and fair course was for the matter at that point to be remitted. Indeed, it was going to be a difficult exercise for the Court of Appeal, who had neither seen or heard the witnesses, to evaluate the material and reach what they determined was a value judgment, their expression, found in paragraph 45 at page, I suspect, 20 of your bundle. Now, even in the Court of Appeal itself, the transcript, which is tab 4, volume 1, tab 4, the learned judges there at page 41, so possibly 49, at line 39, Court, and it's Mr. Justice Patterson, if that is the position, Mr. Manarangi, then Justice Isaac could not determine whether there had been that degree of maturity, could he? No, he didn't. So if we were to come to that decision, are we forced to send it back to him to reconsider that? Or does this court try and determine that from evidence we did not hear? Yes, sir, I've given some thought to that. There were very few findings of fact by the lower court, and it may be a question of whether the matter is sent back to the lower court to hear that evidence and make a determination on what the custom might be. Well, your honours will make a decision, I presume, on what the custom is. Yes, but then it's a question of the application. The difference from Justice Isaac, he may not have factual findings on which to make that decision. Now, there's more of this. If you'd come across 9 more pages, and you see squarely at line 13, learned counsel then appearing for the present respondent.
What is this?
51.
59 then.
51.
51.
59. Yeah.
Thank you.
I'm so sorry. I
51
keep getting this.
59E, yeah.
Plus, Mr.
Plus 8 works, yes.
Thank you.
So where are we looking?
Right in the middle of the page, 48% down.
Yep.
Mr. Manarangi, well, depending on whether you accept the evidence I'm about to take you through. Now, there it is. There's a clear concession by counsel himself for the present respondent that it depends upon whether the evidence is to be accepted, so that the very issue is to be determined. And finally, 2 pages over, which should be 61, at line 20, each of the 3 judges in the Court of Appeal speaks. At line 20, Mr. Justice of Appeal Fisher. So really, the judge, did he review the evidence or, and then Justice of Appeal Patterson, not really because of his legal findings, and Justice of Appeal Barker, or because there was complete family recognition was required, and therefore would have to be no objection at all. That's really why his basis for his reasoning is that right. Now, I won't weary you further. Those are the extracts which show that even in the Court of Appeal, it does appear that the present respondent saw that the interests of justice would require that the matter go back. The Court of Appeal, with respect, erroneously decided itself to proceed. Now I turn, with your ladyship's leave, to the redefinition of family. And the redefinition of family, the timing aspect, and the need for consensus, unanimity. These 3 aspects are core central to the custom and its vitality. If your ladyship would come to Volume 1, Tab 1, the Court of Appeal judgment at paragraph 47, which I now believe should be page 20.
Well, 45 was on 20, so I expect that 47 is.
Thank you.
Yes?
Now, we see here, the Court of Appeal now says this: also requiring clarification is the meaning of family for present purposes. Now, that means for the purposes of succession to ancestral land. There's an ever-widening circle of persons to whom anyone can be said to be related. At some point, the connection between the deceased and distant relatives will be so remote that it would be unrealistic to expect them to play any meaningful part in family attitudes towards the adoptee. Our impression from the cases is that in determining whether an adoptee has been accepted for present purposes, greater weight was intended to be given to the attitude of the adoptee's adoptive parents and siblings than to the attitude of distant relatives. Between those extremes, there may be room for varying degrees of weight to be given to the roles and attitudes of various family memories. And then 48, in summary, as a general rule, a non-blood adoptee has no succession rights unless he or she establishes that at the time the deceased died, the timing point, the deceased's family, paragraph above, had accepted that he or she would be treated in the same way as the deceased's natural children for the purposes of succession. Now, the land is, as a matter of law and as a matter of custom, owned by the registered tenants in common, whom constitute that family. They own it because of their common ancestry. The Court of Appeal has, in our respectful submission, by narrowly confining the meaning of family, really eviscerated the family unit, and wrongly, so that it now consists of principally the adopted parents and siblings. And we submit...
You say that they own it because of their relationship with the family. But if they're registered, do they not own it by virtue of the registration? The registration may have occurred because of the family connections, but the legal source of the title is registration, isn't it?
Correct. That is correct, my lord. The legal
so that produces a finite body of people.
Yes, the legal source is the registration, and that is the error the Court of Appeal made when one comes to consider the timing point. Because until you have achieved registration, you do not enjoy the right. The Court of Appeal, with respect, wrongly saw it as being retrospective, back to the moment of the deceased's death. It is, I'll show you from the legislation, not. It entirely occurs only from the moment you have succeeded through a court order to the registration. And on this occasion, of course, the present respondent had waited over 9 years before he made his application back.
What does registration look like, bearing in mind you say that it embraces the whole family? Does it actually express the whole family as the evidence?
Yes, by name.
Can we see an example?
I'm not entirely sure that there's an extract. It's called the Register of Titles, sets out the names and the entitlements, normally as a fraction, half, quarter, eighth, powers of 2, as the division goes down each generation. So an individual, for example, will own 1/32 of the land, and that's your entitlement. They are all very specific, known and certain. But I will seek to assist your Lordship, Lord Mance, by seeing if we can find a copy of an extract of the title.
And then how does the register, or how does the documentation reflect the fact that presumably one particular person has use of some particular parts of land? Does that appear as an occupation right, or as a lease, or according to whatever it is?
Yes. So if you have, by statute, an occupation right, a lease, or a vesting order, that is on the title and reflects thereupon the rights that flow from that. But when I come to show your lordships very quickly the Constitution and the Cook Islands Act, you will see that the Cook Islands Act 1915, which is New Zealand legislation but repealed for New Zealand but extant in the Cook Islands, is properly very paternalistic because the intention was to ensure there would be no exploitation of people who owned native customary land, the outmoded but current usage still required by statute. So there's no alienation except by court approval. Even the strictures of death, you can't will away your property, you can't mortgage it. So it's in a very restrictive regime. I'm provided at volume 3, tab 39, page 399, so it possibly is 407. Oh, it is 407, I'm told.
You'll have to define which volume. Volume 3 is this little one.
Yes, blue.
Oh, wait a minute. No. Right.
407. Yes? This is headed block name Turamatuti.
Correct. That's Turamatuti.
Oh,
that's exactly right.
Yes,
And it's
And
in
there you
Avarua.
see the 15 siblings, and the abbreviation, I'm afraid, means FA, means female alive. And if you're a minor, your age is put down. And those 15 siblings share equally. So they have 1/15. Depending on how it comes down the generations, the arithmetic will change. So this is the initial allocation in relation to this piece of land, and each has a 15th. Each is a co-owner. They're all tenants in common. Now, before moving further into this issue of the definition of family, may I be permitted to take my lady and my lords to the Constitution. This is purple volume, and it is page 1. In terms of the authorities, I can give you a page reference, 618. Thank you. 618. The Cook Islands Constitution, 1965. If you would turn a page to presumably 619, your ladyship sees there in sort of portrait view an index to the Constitution. I don't intend presently to alight on these sections because of the interests of time, but could I just ask you to look at the far left column? You'll see, cross-heading in bold, the House of Arikis of the Cook Islands, Articles 8, 9, 10, 11, 11A, 11B. Mr. Parker may come to those in the course of his submissions. If you would, however, come across, and I will leave 64 and 65 because of your observations on ground 1, but if you'd be good enough to come to page, let me try and do that.
Do you want us to look at 66A?
Yeah, I'm looking for Article 66, capital A. Thank you. And it's got that cross-heading custom. Now, this was introduced only in 1995. This is going to be a very quick examination for present purposes because this will be fully developed. But sub-article 3, until such time as an act otherwise provides, custom and usage shall have effect as part of the law of the Cook Islands, provided that this sub-clause shall not apply in respect of any custom, tradition, usage or value that is, and to the extent that it is, inconsistent with a provision of the Constitution or any other enactment. So there can be no repugnance to the Constitution or to statutory law, but otherwise it subsists. And sub-article 4 deals with the Oronga Mana, and that's a special matter that'll be dealt with when my learned friend turns to it. If you come to the next item, tab 2, it is the Cook Islands Act 1915, and I need to ask the board to come to the definition for native custom, native land, native freehold land. They follow consecutively. Native custom means the ancient custom and usage.
Sorry,
Where are you?
Oh, I'm so sorry. Sorry? 640. Thank you. I'm grateful.
So
Native
native custom means.
Thank you. Means the ancient custom and usage of the natives of the Cook Islands.
What does it mean by ancient? Does that mean that it is as it always was, or can the custom change?
I would accept custom as not immutable, and indeed the Cook Islands Court of Appeal have plainly said that.
I understand that, but I was just interested.
Yes. I'm not sure that the adjective adds anything for present purposes, only it suggests the origins go back a long way. Native land means customary land or native freehold land, and native freehold land means land which, or any undivided share in which, is owned by a native or a descendant of a native for a beneficial estate in fee simple, whether legal or equitable. And if one moves over a few pages to section 445, and I'll try and do this with some alacrity, part 14, native succession, section 445, wills of natives. No will made by a native or descendant of a native shall have any force or effect with respect to his interest in native land. So you can give away a leasehold remainder interest, but you definitely cannot, through a will, give away your freehold right. Section 446, succession to deceased natives. The person's entitled on the death of a native to succeed to his real estate and to his personal estate so far as not disposed of by his will, and the person's entitled on the death of a descendant of a native to succeed to his interest in native freehold land, and the shares in which they are so entitled shall be determined in accordance with native custom so far as such custom extends, and shall be determined so far as there's no native custom applicable to the case in the same manner as if the deceased was a European. 447, native land not to vest in administrators, and 448, the application made by the respondent, and indeed the counter-application made by the appellant. Succession orders. On the death of a native or descendant of a native leaving any interest in native freehold land, the Land Court, now the High Court Land Division, shall have exclusive jurisdiction to determine the right of any person to succeed to that interest, and may make in favour of every person so found to be entitled, hereafter called a successor, an order defining the interest to which he is so entitled. If you come to 451, now this with respect is where the Court of Appeal went wrong in relation to timing. I wish to bring to your attention that these provisions were simply not brought to their attention by any party appearing below. No successor shall be capable of instituting in any court other than the Land Court any action or other proceeding relating to his interest as such successor until and unless a succession order has been made in his favour. And 452, no successor shall be capable of making any alienation or disposition of the interest acquired by him as successor other than an alienation or disposition by will in the case of a European until and unless a succession order has been made in his favour. Now, my lady, on the next page, but I don't want you to be misled, because the next page, which is page 648, you will see that we have actually moved from 452 to 462. It's appropriate and proper that I tell you that the cross-heading is adoption of children by natives. It's part 15 of the Cook Islands Act, and it's, quote, adoption of children by natives. And 465 an order of adoption shall have in respect of succession to the estate of any native the same operation and effect as that which is attributed by native custom to adoption by native custom. So it circles back to the definition in section 2, and it ultimately comes to the ascertainment and content and application of native custom. I bring to your attention in 465 capital A, this underlines the importance of native land, because no order of adoption other than an order made under this part and the 1921 window that closed a long time ago and another part shall have any force or effect in respect of succession to any interest in native land. So an adoption in New Zealand, Australia or England fails for the purpose even if you are a Polynesian descendant.
But it's common ground, is it, that the adoption order made in this case was made under this Act?
Correct. There is no doubt that it was a lawful and no doubt joyous adoption made under Section 465. Then the next part, which I hope I can move through even faster, your ladyship permitting, is part 16, alienation of native land. And here one sees a number of significant restrictions, and indeed your lordship, Lord Manson, Lord Lady, in your advice in the earlier Cook Islands cases have examined these restrictions and shown their general intent is to maintain vigorously customary law and protect, in a sense, the native freehold owners from themselves, the paternalism of the 1915 Act. 467, alienation of customary land is prohibited. No person shall be capable of making, whether by will or otherwise, and whether in favour of a native or a European or of the Crown, any alienation or disposition of customary land or of any interest therein. Alienation in fee simple prohibited. 468. Alienation for a longer period than 60 years prohibited. So this is the lease and license provision. So after 2 generations, it comes back to sender. 60-year maximum, section 469, subsection 1. Thereupon, it reverts to the native freehold owners. It can never leave the system. That is the manifest intent of the legislation. 470, alienation by way of security. Mortgage, for example, is prohibited. From that, I can very quickly move, if you permit, to Section 50 of the Cook Islands Amendment Act 1946, which is 39 in my bundle and is 658. Thank you. I'm obliged. Forgive me, my lady, when we're crossing the equator, things have obviously gone wrong with the electronics. 658. Now, you find here in Section 50 of the 1946 amendment, this is, in a sense, a derogation from the original Act structure, because it now permits what is called an occupation right. Land Court may make orders as to occupation of native land in any case where the Land Court is satisfied that is the wish. Now, I want to show you the word majority, because this is the one time in this Act that the word majority is used. It is for the licensing provision in relation to an occupation. It's the wish of the majority of owners of any native land that there should be an occupation order, then the court may grant it. And it's effectively a bare license. Now, at this juncture, might I ask your ladyship to stay in the same bundle and come to a judgment of the Cook Islands Court of Appeal and I will be able to give you the reference. It is the case at 896 in your bundles. And in the hard copies, it is still the purple bundle, and it is item 29, tab 29. This is a case, and for convenience I'll just use the last names, Ihaka against Nicholas, a judgment of the Court of Appeal, Sir Thaddeus McCarthy presiding, the former New Zealand Court of Appeal president and indeed a member of this board. And the significance is there is a consideration of the meaning of the word majority in section 50 of the 1946 Act. And if you come to 2 pages across, so it'll be the 3rd page of the judgment, at the last full paragraph commencing with these words, the reference in section 50, sub 1, is to the majority of the owners and not the owners holding the majority of the shareholding. On a normal reading, the phrase would mean the majority in numbers and not in shareholding. And then if you turn over the page, the Court of Appeal here was dealing with the practical problem which they recognised even from 1985, and they say it in terms, 10 lines down, the number of Cook Islanders residing in New Zealand now far exceeds the number residing in the islands themselves.
267, thank you.
And to deal with the difficulties occasioned by that, and I'm not straying back impermissibly to ground 1 more than I just very tenderly wish to do, you see the consequences that the Court of Appeal recognised the effect of mass immigration. First 3 or 4 lines, they repudiated what the High Court had done, because the High Court, frankly, invented a practice that despite the legislation, if 90% of the owners resident in the Cook Islands consented, that would do regardless of the position of others and whether they knew of it or not. And the Court of Appeal in 1985, at the end of that first full paragraph, recommended there be amending legislation and even suggested it may be retrospective to give practical guidance and to consecrate what had in fact happened. Now, if I can, from that, quickly move to what your lordships decided in this board in Utanga and Tumu. This is found at tab 16 and it's page 748. The joint advice given by Lord Walker and Lord Carnwath, and your ladyship's asked to note in particular paragraph 2, where the board made itself very clear the observation that the special character and importance of ancestral property to the indigenous peoples of the Cook Islands, which transcends any commercial significance. This has been recognised by domestic legislation since 1901, and as will be seen, such property is generally inalienable, subject to restrictive conditions supervised by the courts.
I'm sorry, Mr. McCoy, I missed your page number.
Forgive me, my lord.
748.
748, thank you.
And paragraph 2 is on 750.
Yeah, thank you.
Thank you. And if you would also note paragraph 5, just the first part of the sentence, so apart from Crown lands, the general effect was to keep in place the substance of the land law of the indigenous Maori population, and paragraphs 14 and 15. And in particular, those two paragraphs really catalogue the substantial restrictions on alienation and give your ladyship the full context. And if we move just to the next case, Baudinay and Tavioni, the second case decided by the board, and I apprehend that that is at 776 on its first page. And I would ask you come into that judgment at paragraph 13. Lord Mance sets out as an extract at the end of that paragraph, indented this from the Cook Islands Court of Appeal. Cook Islands litigation over family land impacts upon all those family members who have a present or future interest in that land. And it was for that reason the courts allowed a party who was affected, who otherwise had not participated, to come into the Court of Appeal as an appellant. Now I would wish to take your lordships very quickly to the seminal judgments of the Cook Islands Court of Appeal, and I hope to do this with some real speed. Could I ask you to come across to a case, one of the cases we place particular reliance upon. It is tab 28, and it is page 886 in the electronic bundle. And we simply call this the Paura Ri'i case. Again, first two members of the court, members of this board, and Sir Clinton Roper was the Chief Justice of the Cook Islands. If you come into the...
So, forgive me, what do you call it, this case?
A Paura Ri'i. So you see the name is in the intitulment.
Pari.
Yes. Thank you, milady.
E-E.
E-E. Double I, yes.
Yep.
Yes. And if your ladyship would be kind enough to come to the third page of the judgment, top centre of you see the page numbers, and then Sir Thaddeus McCarthy for the court said this: the retention of the use or control of land within the group is a central feature of Polynesian philosophy throughout the Pacific. Land is often scarce and it is always precious. It must be retained for those of the tribal blood and not eroded by allowing others of different descent to occupy it. Native custom is moulded by this inherited instinct and has made blood connection the primary consideration in succession to native land.
I'm sorry, on which page was that?
Oh, forgive me, page 3, my lady. So the judgment commences at page...
Yes, I see it.
Yeah.
Yes, I did it.
So sorry.
No, it's my fault.
And again, perhaps in the interests of time, if I just ask you to come over two authorities to tab 30, and this case we will find at page 902 in the electronic bundle, and I will again, simply for convenience, use the last name of the parties, Kainuku against Nia, Kainuku against Nia. Again, Sir Thaddeus McCarthy, and this case happened pertaining to a disputed election of a paramount chief or ariki. And what is significant is the second paragraph of the judgment. And I anticipated this when your ladyship asked me a question earlier. The indigenous Polynesian peoples of the Pacific have a rich history of customs which have managed their lives from the commencement of their recited history and still continue to do so. These customs should not be seen as invariably monolithic, immutable, and demanding rigid compliance in detail. Rather, they present a picture of evolving social living which varied in practice to meet the changing attitudes of different times and separate groups of people. But always, it seems, they played an overriding part in cementing social living, especially in preserving separate tribal units and enabling retention of tribal lands. And His Honour continued to point out the difficulties that can be occasioned because of the strong feelings in relation to custom. But it identifies that custom is a positive life force for Cook Islanders. And then, if you would turn to the case called Tiariki and Strickland, and this is page 948 in the bundle and tab 31 in the hard copy. Sir Maurice Casey, a member of this board, presiding, together with other learned judges. And the points I would ask your lordships to note, there are a number of them, but they can be considered perhaps just at paragraph 18, 17, 18, 17 if you permit please. One sees the heading, was an equitable solution legitimate? We can understand and even sympathise with the judge's approach, but we are unable to hold it. The Court of Appeal in the case of Pa'ari'i had said, we do not find that argument convincing. What we're required to do is to follow the appropriate native custom, not to impose what we ourselves might think was a more fair result than the custom produces. The custom in paragraph 18, the Court of Appeal said they were satisfied, third line down, that there was evidence which established the custom before the judge. I won't go through this, but this is the House of Ariki's recommendations, and it falls more naturally into my learned juniors area, but it sets out there in great detail the custom. And if you would come to paragraph 25 of this judgment.
On page?
Page, forgive me, 954. 954, my lord. To echo Sir Thaddeus McCarthy's words in the Aitotarangi case.
This is not conforming to anything that I have read on the screen at all, anything that you have just read out.
I've got a paragraph 25, but it says something completely different.
And so did your earlier paragraph say something completely
Yes.
different. Yes. Sorry about this.
Mine figures perfectly.
Yours, his works.
Well, my lady, forgive me if I may have to ask you to go back to the more Luddite approach to this. I'm so sorry. For those, can I assist? What I had read out previously was tab 30, pages 1 and 2, and now
Tab
31.
The page you were reading
in the case,
is actually 942 on the electronic.
I see.
It's a different, yes, it's the,
942.
The one you've just turned to.
yes,
Yes,
and it's
okay.
Tamati and Matamina.
If you can revert to tab 31, so it's no, Tiariki and Strickland.
Well,
So, no, wait a minute.
tab 31 in my
that's-
hard copy is not Tiariki and
No.
It's Short and Whittaker.
We have it. I thank you.
It's tab 31. That's the one from which you've recently been
299.
quoting.
Yes, thank you.
And tab 32
Yeah.
is the Tiariki and Strickland
Yes,
case.
I certainly am obliged. Thank you.
So which one are we now going to?
Yeah. Can I ask you to look at the case at tab 32?
That's the Strickland case.
Tiariki and Strickland,
Yeah,
correct. And this one, fortunately, has paragraph numbers.
Yes.
And if you'd come, please, to paragraph 43.
But the passage you were citing from Short and Whittaker is an important one, isn't it?
I will return to that. I think we
All right.
have the answer. Thank you, my lord. Paragraph 43, and I confirm again we are in Tiariki and Strickland. There the Court of Appeal said, we accept that identifying land interests through the relevant bloodlines is of cardinal importance in Cook Islands custom. But on the basis of the materials before us, we cannot reach a conclusion that as a matter of custom, an adopted child who's not of the blood only ever takes a life interest. So the point that's being made there is a child not of the blood may be able to obtain a freehold interest. But as the court continued, there will be circumstances when that is so, only obtaining a life interest, but it's not an inevitable conclusion in all cases. So,
do they explain in what circumstances the exception applies?
no, but the custom is determined on our case by the consensus model. And can I just try to make this pragmatic for your lordship? The applicant has applied for all 19 parcels of land. They could have allocated him less, but he didn't go through the stage of seeking the consensus model. He took a divisive and strategic strategy of going to court by himself. And that unilateralism is the very antithesis of the co-ownership ancestral model. So he went to court.
It appears to be common ground that there is no absolute right of an adoptee to succeed.
Correct.
The issue is what are the conditions. The two alternatives that we are being offered
Yes.
are maturation and nothing else, and unanimity of the surviving co-owners. Where in the authorities, if anywhere, do we find discussion of which of those alternatives is correct?
Apart from the judgment below,
Nowhere.
nowhere.
So none of the cases decided in the courts actually deal with this question. They only deal with the question whether there is an absolute rule against succession by adoption.
But
Is that right?
to fully answer your lordship, but the materials from the House of Arikis
I understand that. but
provide the answer.
I understand that that's your submission. But is it right that the cases which accept that there are circumstances in which succession by adoption is possible, none of the cases deal with what those circumstances are? Or do they?
No, there is, and perhaps I should now ask your lordship to look at this judgment. There is a judgment which has existed for 60 years. It's a judgment of an appellate court before the creation of the Court of Appeal in 1981. 60 years, which in the Cook Islands means certainty, I would submit. And that sets out very clearly the issue.
Which case is that?
Yes, it's called Re Mo'au, and it is at page 846.
Tab?
Thank you, my lord. It is at tab 21. And
Mine's a very bad print. Is it M-O-E-A-U?
M-O-E-A-U,
M-O-E-A-U.
Re Mo'au,
Yeah.
1957.
It gets better, but that's almost illegible.
My lord, many of these judgments are actually, it seems, secreted away in priest holes within the profession, and this is probably the best ever single collection of them.
This seems to be 1957, is that right?
Yes, it's 1957, and it's the appellate court, the predecessor entitled to the Court of Appeal, Chief Judge Morgan, of whom the courts of appeal have always held the highest respect because he lived in the Cook Island for 30 years, together with two other judges. And the point I would ask you to come to, and I'm sorry, the quality of the original is the best that exists. If you would be good enough just to come to the second page. And it's the fourth or fifth line down, or incorrect full stop. We do think, however, that it would be in accordance with native custom for the family of the foster, they mean adoptive parent, to set aside lands in addition to those allotted to the adopted child at the time of the adoption at a later date, either during the lifetime or after the death of the adoptive parent, for the benefit of the adopted child and his descendants. The persons who would have the right to set aside such lands would be those entitled to succeed if no adoption had taken place. Now that makes 2 points. One, it shows that the Court of Appeal's judgment on timing actually is completely at odds with what had been the settled law for 60 years. Because if you can take into account the family's decision after the death to allot lands as being in furtherance or fulfilment of co-ownership rights to whatever extent they agree, that's destructive of the timing issue. But the better and much more fascinating point for present purposes is, since for the last 60 years, it's always been clear that the other parties who have the rights are those who would be entitled to succeed. And because it's collective co-owned land, that is the tenants in common. This demonstrates most poignantly the nature of the custom.
Was this a non-blood adoptee?
I'm not...
Or is it not possible to tell?
I think the latter at the moment, but if I'm wrong, I'll be instantly corrected, I'm sure. But I think it's not possible to see. You can see over on the right-hand column the fractionated entitlements of the various people who were given the interest.
Yes.
Now, if we were really digging into custom, one might have expected to see the notes on adoptions by Judge Ayerson, which are referred to at the top of that page and the foot of the previous page. Where are they?
Now,
they're in some memorandum book.
Yeah, the reference MB is minute book, and that can be taken as the contemporary of the yearbooks of the 13th century in terms of their availability.
Yes, well, somebody's obviously examined them.
Yes,
where
yes,
are they kept?
No,
Where's minute book 22/320 with the attached notes on adoptions?
Yes.
That might be very good, very interesting.
I have not got that to give to your lordship. I'm sure we could cause it to be broken.
Because the bit you just referred to is evidently a qualification of the principles outlined by Judge Ayerson, which suggests that those principles are no person not of the blood can adopt.
Yes.
And the qualification is, yes, well, all right, but it would be a very good thing if one recognised that the family should modify that. But it would be helpful actually to see it.
Could I sorry,
No,
answer that question first.
Forgive me. My lord, the problem, of course, is there are no series of law reports. So what one really has is this wilderness of individual judgments as opposed to a demonstrable, cohesive set.
Where are the minute books kept?
They'll be kept in the Department of Justice, a function of the court. Yes, they'll be there.
What, in New Zealand?
No, in Cook Islands.
Oh, in the Cook Islands.
Oh, yes.
Well, I mean, I don't know how easy and how accessible, but
I'm told we can get a copy.
someone could look out the notes.
Yes,
Right.
yes.
And actually the same applies, though it's rather less specific, to Chief Judge or Justice Morgan's observation in the Emma case that he'd looked in the minute books and found some interesting cases, but since he doesn't identify what they are, if I recall rightly, that may be a rather more difficult exercise.
Yes, I mean, I fully...
But this one looks interesting. I mean, when did Judge Asen operate?
In the 30s.
In the 30s. So he was a successor to Colonel Gudgeon, who I remember from the previous case.
Correct.
Yes.
But your lordship will appreciate also that the House of Ariki papers are in the 1970s, and the courts of appeal after the House of Ariki's papers have decided that they have strong evidentiary values, and much of the earlier stuff, which seems to be almost anomalous or irreconcilable amongst themselves, very much one-off decisions, no reasoning, simply assertions, have been, in a sense, forsaken. But this judgment is regularly cited by the Court of Appeal in the cases which we have brought to your attention.
Right, so basically it's the qualification which you rely on as showing the basic principle.
Indeed. And might I...
Before we leave that, if I may,
yes,
the last sentence in the paragraph you read to us was the persons who would have the right to set aside such lands would be those entitled to succeed if no adoption had taken place.
Yes.
And you equated that with all the whole family.
Yes.
But is that what it's saying? Is it not saying, let us say there's a foster parent who has who adopts a son. He has a sibling who's died, there's a nephew and niece, but for the adoption, the nephew and niece would succeed to those particular lands. So it does not seem to be saying it's those who would immediately benefit from the lands if the adoption did not have the effect that was desired.
We would submit that the intention of this passage is to show that because it is communal land, all the co-owners have that right, and they are the parties who would succeed. If there is no successful application for succession, then, as I indicated, everyone else's rights get very slightly altered larger. So that is the emphasis and thrust. You cannot give the freehold. The most you can give would be either a vesting order, but the vesting order has to be given by the family. No individual can give it away. So the only thing that, and this is one of the errors with respect made by the Court of Appeal, when it took into account the lease said to have been given to the respondent upon the death. The will's not in evidence, but just putting that inside, the will can only be the remainder of a will. It cannot be the freehold, and it cannot be an occupation right because that requires the majority of the members, and it cannot be a vesting order because that requires all the members of the family. So whatever's to be given away is a very, very minor interest.
Well, it's rather odd that the learned judge chose to word that last sentence as he did, if what he was meaning was all the co-owners.
I'm not sure I understand it fully either, because, I mean, although you say that all that's intended is a very minor interest, it seems to me that the phrase is set aside lands in addition to those allotted to the adopted child at the time of adoption for the benefit of the adopted child and his descendants. That seems to contemplate that the adopted child will get the lot, effectively, not just a partial interest, but will so to supersede. And then the last sentence, if that's right, could well mean that you have to get the consent of all members of the family who would otherwise succeed as co-owners because they are being replaced rather than supplemented. Yes. But is that what it means, or is it?
Yes.
It does. So this is postulating in some way you shunt all the co-owners who would otherwise be co-owners out of the picture, and you substitute...
Forgive me, my lord, I have completely misapprehended this. Sorry, it's not what I submitted.
Well, no, I didn't think it was what.
No, it was my fault.
I mean, it reads.
It's a disability.
It reads if you allot someone in lands, in addition to those allotted at the time of adoption, for the benefit of him and his descendants, that seems to suggest they're getting the lot, and nobody else will have an interest now. And that's why the last sentence, on one view, that's why the last sentence says, well, everybody else who would otherwise have a co-ownership interest has to be agree. But you don't agree with that? No. You say it would be a totally aberrant reading of...
Indeed.
Yes.
And might I take your ladyship very quickly to the pink bundle, tab 58, which is page 1368. And this is the New Zealand Law Reform Commission paper of 2001. It's referred to by your ladyship, Lady Hale, in Baldane and Tavioni. And if you come, please, to paragraph 130 in that document, which is 1386. And one sees the heading whānau natanga. Of all the values of tikanga, Maori whānau natanga is the most pervasive. It denotes the fact that in traditional Maori thinking, relationships are everything between people in the physical world, between people and the atua spiritual entities. The glue that holds the Maori world together is whakapapa or genealogy, identifying the nature of relationships between all things. That remains the position today. In traditional Maori society, the individual was important as a member of a collective. The individual identity was defined through that individual's relationship with others. It follows that Takanga Maori emphasised the responsibility owed by the individual to the collective, no rights inured if the mutuality and reciprocity of responsibilities were not understood and fulfilled. And if I could very quickly just ask you to come across to paragraph 167. In 167, the heading is Takanga Tangata Social Organisation. In the interest of time, if you'd come to the cross-heading above 170, whānau refers to the extended family. It also means to give birth. In Cook Islands, I understand, it means placenta. The whānau was the basic social unit of Maori society. Whānau usually included grandparents or great-grandparents and their direct descendants. And that represents still the entire concept on which the customary land is owned and administered, and decisions are made in relation to it. Now we submit, therefore, the learned judges in the Court of Appeal misunderstood because they weren't properly had brought to their attention the statutory provisions about timing. The timing links to the notion of who is the family who makes the decision in time. The family has never been a narrow Western nuclear concept. It is intergenerational, and the family are the co-owners. Not a subset of the co-owners can decide. No Cook Islander within the family can decide anything by themselves in relation to customary land. They simply are precluded from doing that. That is why it is a collective decision, and the consensus means unanimity. In the very small example where the legislature has intervened by identifying majority, that is in relation to the least interest in land, a bare occupation right, but into the apex interest, who comes into the clan, who comes into the tribe, that is a decision of everyone. and they may approbate, they may not. It's not exactly a binary decision. They can reach a decision that lesser interests be given to some lands. And that is why in 2007, after the deceased had passed away for 2 years, the family gave the vesting order. That's why they gave the vesting order, we would submit. The vesting order itself is, however, the subject of other proceedings presently before the High Court, and they have been stayed pending any adjudication by your lordships, because the vesting order is made in the name of the respondent and his wife, and the tribe never gave any vesting order with respect to his wife. But that is not a matter that should otherwise presently occupy your ladyship. Other than you know, there is contentious litigation in relation to the vesting order. Sir Hugh Williams, Chief Justice, has stayed that pending any impact this case may have.
What interest does a vesting order vest?
Now, a vesting order gives a life interest. But if you are a member of the family, that is, if you are also a co-owner under ancestral law, it becomes a permanent interest. It's odd. Perhaps I could show your
Well, if you're in that
lordship.
position, you always were a permanent.
Sorry, forgive
If
me.
you're in that position, surely you always were entitled in perpetuity to an interest in the land, or have I misunderstood it?
Undivided shares, a tenant in common,
Yes.
you don't have any differentiated part. You only have the
But
unity
you have a
of
heritable,
possession.
you have a heritable interest, and you always did.
He does not. He does not. He can only inherit from his father other than freehold land, and all he inherited was the residuum of the lease.
Well,
Vesting
depends what you
order
mean by...
puts in- Sorry.
I think we're probably not quite agreeing about what we mean by inherit. If inherit includes succeed to by native custom, that's one thing. If it
He
means
cannot. He cannot unless he has succeeded through section 448
Yes.
to be a co-owner.
But does the vesting order give an exclusive life interest, i.e. that person is
Yes.
the sole owner, the sole person with a right to enjoy the land,
Thank
to
you.
the exclusion of the other tenants in common, but
Yes.
just for his life?
Yes. Now,
Right.
may I show your lordship that? Forgive me, I'm being unhelpful. Can I ask you to purple bundle? And you'll see this provision. It is tab 5, and in the electronic bundle 660. And it's section 23 of the Cook Islands Amendment Act 1916, and you'll see the massive limitations on a vesting order. The Land Court may, in its discretion, on application being made to it by an owner of any estate or interest in any native freehold land, make an order for the transfer of any such native freehold land to a native or a descendant of a native to provide him with a site for a dwelling. A vesting order may be made in favour of 2 or more persons. Subsection 2, no vesting order shall be made vesting any area exceeding 1/3 of an acre in any one person. So it's a very small parcel of land for the very specific purpose of building a dwelling. Now, in the Court of Appeal,
Where's the provision for notice to other people who are interested, other members of the family?
then you have to come back to the rules of court,
I see.
the very provision, rule part 33, that is the subject of ground 1.
What, and you said, and Mrs. Browne, her succession was irregular because she's, because what?
Well, Mr. and Mrs. Browne applied, but they can't apply
She
because the
wasn't
person
there.
who applies are the owners.
Yeah.
And secondly,
Yeah.
she was never
She was
permitted
never
to
an owner.
succeed.
Yeah, on any
Yeah.
basis.
Yeah. But, my lords, the confusion there may be an answer to this if I show you the transcript in the Court of Appeal. This is Bundle 1 Blue, tab 4.
My blue starts at tab 25.
Thank you.
No, that's a different button.
This is the record volume 1.
Yes, my lords.
Okay,
Yes.
sorry. Right. My mistake.
So which tab was it?
Tab.
So where are we going to?
Yes,
We're going
I'm
to the Court of Appeal, aren't we?
I'm just finding you the passage.
In the transcript.
I see.
Now, you'll find the passage at page 85, which is page 37.
Page 36, electronic.
So I believe.
Yep, well, it is transcript, certainly.
Right?
Yep. 93. I'm told it may be 93. I'm so sorry.
But the paper, what is the page number at the
66. Original 66.
66, that's page 85. Yes. Thank you.
And one sees at line 19, Mrs. Carr.
We're nowhere near with
Nowhere
you,
near at the moment.
because we've been given so many different numbers that it's really rather tricky for us.
Right. Then I regret this, plainly, the lady.
Don't worry.
Well, I'm now on
Eyes.
a page that starts, Mrs. Carr at the request of the next of kin.
I think the page you're wanting us to
Yes,
refer
I
to
am
is
coming to
Mrs.
that.
Carr, yes, I'm coming to that. At the top of the page.
If you search for yes, I am coming to that,
Yeah.
you'll get there.
I think we need the
Hard
hard copy page at the bottom.
I think the better course is presently to abandon this. But can I tell you, I will find it and give it in indefatigable terms to you when I find it. But
You are you're very patient with us, but
no, I think it's the other way round, my lady.
It should be 93, shouldn't it?
Oh, I've got it, yes, it's electronic 93, it is.
Yeah, it should be
Yeah.
yes, I've got that.
Yeah,
Mrs. Carr at the top, yes, I am coming to that, but I'm
Yes.
not saying that.
No?
That page.
That page.
Thank you.
That's 93. Well,
Yes,
you
sir.
said it was 85, so
Yes.
adding 8 is 93.
now we're
That's fine.
there.
And if you come to line 19, you're actually at 15, you see, I'm sorry, I'm not trespassing back to ground 1, but you see the point. You suggest the practice is, says the court, if there's no objections, the court will go along with it. That's the usual procedure, that's the practice, i.e. people don't know the case is on. Mrs. Carr, that's the practice. And so in terms of the judgment, how we can understand where the judge got to was that all of the tenants in common must agree together to give the interest away, and native custom allows it. If one individual person or 7 people were to say, well, I'm to give mine away, you cannot do that by law. It's such a precious and important aspect. And then turning over, please, to where we find our learned friend, Mr. Manarangi, coming back into the fray, he comes 2 pages over,
Yep.
which should be 95, at line 34. And at line 39, he says, we're only concerned about the freehold and then succession to the freehold. And then if we turn over 2 more pages to 97 at line 30, our learned friend, Mr. Manarangi, I can perhaps repeat the position that the appellant would find himself in without succession to the freehold. That means to be taken into the freehold. That's because the best I can put it, he and his children would become disentitled to the enjoyment of the land that they now live in on the land that has been allotted to him during his foster father's life. There's in particular 2 sections, which is part of the much larger one, Turumatuti, where there is a vesting order, and in relation to that vesting order, his children would not be entitled to succeed if he were not able to succeed to his adopted father. The freehold of the vesting order. And now you find the court struggles with the confusion that perhaps your lordships have been struggling with on that page. They seek to understand the true nature of a vesting order, and you'll see at line 14 that the court very clearly says that it's not the understanding of the court that section 23 transfers the native freehold land to another native. Mr. Counsel at line 17, yes, well, the order itself will set out the terms on conditions, and a few lines down at 23, no, that's all right. It's just that your interpretation of vesting order, I might have got this completely wrong, but I don't see how that could be reconciled with the notion that the whole block is owned by all the members of the family as tenants in common. That's because all of those owners agreed to a transfer of part of their interest in the appellant. So I think we find it at that point. Everybody agreed to the vesting order, which is this right to have land on which to build a house, and that was given by the family in 2007. The Court of Appeal, with respect, wrongly held and reasoned because of the vesting order, and I remind your ladyship, on their own ruling, the vesting order is inadmissible because it's 2 years after the death. But putting that to one side for present purposes, the significance of the vesting order is its insignificance in relation to the 19 parcels of freehold land. We would respectfully submit it is not logical in terms of an irresistible inference to say that because you've been allocated a very small piece through a vesting order, that that is the evidence of succession to the freehold. Indeed, it's the very opposite. And that is the mistake that we submit the Court of Appeal came to, having first of all wrongly denied the true understanding of family, wrongly identified the correct time, and wrongly denied the need for consensus. And if you were to come to electronic bundle 406, and in the hard blue bundles, volume 3, at tab 38. And this is the resolution of the assembled owners. This is the tribe, the whole tenants in common. It is hereby certified that the following resolutions were carried by the assembled owners of the above-mentioned block. That a deed of lease of 1981, now vested in the respondent and his wife, and then there's the description, be varied by extending the term of the deed of lease by a further 5 years, and then a vesting order be granted to the children after the 40-year lease. So the children were always going to get the land.
Well, get the house.
Yes.
Yes.
Yes, exactly, my lord.
The plot
exactly.
with the house on it.
Yes, exactly.
But
Of course, in London, we think 3 acres was an absolutely huge plot of land. Or a third of an acre.
A third of an acre.
Of an acre.
A third of
we
an
would think
acre.
it enormous.
I understand
the density of population is somewhat greater.
But I don't wish to make things more complicated. It talks about the resolution of the assembled owners.
Yes.
Is that they just happen to be the ones who are on the island? Or?
Probably.
And do they have a right to speak for the consensus?
Yes, anyone can object. Now, there is an Act of Parliament of the Cook Islands enacted in 1970 called the Facilitation, Land brackets Facilitation of Dealings Act. It's actually in tab 9 of the purple bundle, 694 of the electronic bundle.
Did you say 694?
694.
Thank you.
Thank you, my lord. And this was designed so that when you're dealing with issues like occupation rights and leases, that there be an expedited way to prevent delays. But it does not, and this is the point I wish to emphasise, it absolutely does not deal with the apex entitlement to freehold land. It deals with the lesser interests, and it provides that...
Which section?
For example, section 53, my lord, resolutions for alienation of land. And it comes with protective mechanisms in any event, such as a valuation in case there's exchanges and in case there was any perfidy. It also provides that tenants in common in ancestral lands can be incorporated. But unfortunately, there are very few such incorporations. In that situation, service on the incorporation for the purpose of the High Court rules is easy as service on the co-owners.
Where do we find that sections like section 53 are only concerned with subordinate interests?
In fact, okay. My lord, there's no power to give away the freehold at all. So you don't need any provision because it can't be done, because the Cook Islands Act prohibits it. All that can be done, the most that can be done, is the lesser interest, to wit, a vesting order. Your lordships...
So this is basically purely procedural adjunct to rules that are to be found elsewhere.
Exactly.
Yeah.
My lords, you just might derive some assistance. I say that, obviously, with some care. In the purple bundle at tab 33, Ritarapo, which is an electronic bundle, 962. Now, this is a judgment of Mr. Justice Isaac from the judge who was the chief judge in New Zealand of Maori land for all those years. And he sets out, I'm not going to go through it because of the interest of time, but
Which time are we in?
forgive me, 33. So Ritarapo, this judgment between paragraphs 36 and 46 sets out an analysis of vesting orders. And in paragraphs 45, in my view, the words "any such interest" refer directly to the estate or interest held by the owner or owners wishing to vest. Section 23 therefore clearly means that an owner of an estate or interest may apply to the court to transfer that specific interest to another owner or native. This section does not enable an owner to vest more than he or she has. It does not provide the ability for an owner to obtain the tenant in common interests of other owners without their consent, or to utilise a vesting application as a quasi-occupation or quasi-petition application.
335, large 335.
My lady, I see there is but a few minutes before lunch, if I can just perhaps return to the issue of timing, we would respectfully submit that as a matter of sensibility to concentrate on the position at the time of the death would not be concordant with Polynesian concepts. Indeed, they may well consider it to be macabre to do so. This is really demonstrated by the jurisprudence in relation to disputes over chiefly titles of ariki, because they happen because there has been no approved succession. And it means the titles may be in abeyance for quite some time. That is a price the people of the Cook Islands are willing to accept, because it's their identity. What the learned judges of the Court of Appeal have sought to do, in a sense, is they have tried to inculcate a more business-like approach that would create a generated efficiency, if in terms of succession planning found in many organisations. But it simply undermines, dilutes, sullies the fundamental approach of the Cook Islands to take time to build bridges in a very tiny jurisdiction. If you have more discord than you otherwise need, the way to resolve it is essentially by a mediation process through consensus. It can take time. And I also bring to your attention that the Court of Appeal have even held, in relation to these types of applications under Section 448, that the res judicata principle doesn't apply, because with a change of circumstance, you can come back again and there may well be a different outcome because of the dynamics of the situation. It just simply identifies that consensus decision-making is the norm. It's a function of time and experience, and often there can be healing of fractionated relationships. One last point to fit in, and then I will defer to my learned friend, I suspect. This is simply the freestanding point about the notation on the adoption order. I would wish to show your lordships the actual document. It's volume 3, that's Blue Bundle, tab 28, and I'm going to be assisted to my left. No, not tab 28. Just forgive me, I have it. I'm just looking for a sort of a clearer version, conscious of the observation of Lord Briggs earlier. There is a clearer version. It is... we may have to come to the original. I'm so sorry at the moment. My Lord's, tab 31, page 383, and that is 391. Oh, it's still the +9.
Yeah,
It's 8.
+8.
8.
Yes,
Difficulties with my handicap.
Not very easy to read, but...
No.
Is there an agreed transcript of it?
There can be, my Lord. That can certainly be done. It's the last half of the page. Yeah. Adoption of Richard Browne by Kurai Browne and Richard Browne. Kurai Browne sworn. So she gives sworn evidence. Richard is a boy born in 1948. He is the son of XYZ, whose name was, and the father's name was not entered in the register. And then it goes on to say Richard is at a particular college. And then the separate lesser paragraph to the judge. I agree, the boy will not get our lands, brackets, he has already succeeded to a number of his natural mother's lands. And then the order in favour of Kurai Browne and Richard Browne, and you see at the last line, not to affect succession to lands. Now,
What's written against that to the right? There's some bracket and then there's some more words.
Slightly diagonal.
yes, I see it. There is a better,
The
clearer...
boy Richard Browne, something.
Yeah, my Lord, we will achieve what Lord Briggs required. We'll obtain an agreed transcript of this. I'm sorry, that really is demanding, asking you to look at that handwriting. But
I just thought there might have been one by the time the matter reached the Court of Appeal.
they must have understood it.
Yes. Well, the parts you've drawn our attention to are clear. It's the little bit at the bottom right-hand corner that really...
Yeah, I understand. I understand. Now, my lords, the point is very short, and I can deal with it in all of 3 minutes, with your lordship's leave. These notations on adoption orders were very common. In fact, the judge who made this adoption is Chief Judge Morgan himself, regarded as the leading authority on customary law matters. And in subsequent decisions, the courts have gone on to undernourish the value of these notations and the sworn evidence by saying it's not provided for under the adoption provision. That is, there's no provision under the Cook Islands Act for the judge to have made the notation. Well, that might only be correct in half. On our submission, and this is the proposition, this represents the best evidence of custom as understood by the family.
Well, it could equally be evidence about maturation, couldn't it?
Exactly.
But I mean, that doesn't get you home, though,
No,
does it?
my lord, but this remains enduring evidence, and your lordships may accept the oral tradition of the South Pacific. On an occasion like this, everyone in the extended family will know what has been said. That is how important this is. Now, this notation has, we submit, its real value is it consecrates the status of customary law for this particular family in relation to this particular adoption. And it could not be clearer. A reason has been given. So the respondent in this case has, in a sense, triple dipped. I know it's a pejorative expression, because he seeks to inherit from both his adopted parents and also from his natural mother, his natural father being unknown. But it also means there can be situations where people inherit through 4 different sources. And this has been, in the Cook Islands, the source of very specific discord, and it's demonstrated in legislative papers as being the rationale and the reason why the notations are made, to prevent this sort of point being resurrected later on, that you have an entitlement to succeed. Well, my lady, I see that I've outspent my occupation order, and your ladyship willing, those are the submissions at this stage.
Thank you very much. And as I understand it, we'll look forward from hearing from Mr. Parker at 2 o'clock. Thank you. Board will now adjourn.
Thank you.